Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the Fourth Circuit Court of Appeals. This is a case from the state of Virginia in the case of Tina Ray versus Michael Roan. In this case, a police officer shot a dog who was tethered and posed no threat to the officer. The court is being asked to consider whether or not this is a violation of law and whether or not the officer has immunity under 42 U.S.C. 1983. So let's figure out if the officer has immunity for shooting the dog, even though the dog posed no threat. Let's get started. On September the 24th, 2017, Roan drove to Ray's property to assist with an arrest warrant that was being served on Ray for domestic abuse. When Roan arrived on Ray's property, 4 other officers were already present and parked in the driveway. Ray's dog, a 150-pound German Shepherd named Jax, was secured by a zip lead attached to 2 trees that allowed the animal limited movement within a play area of the yard. Rather than park in the driveway like other officers, Roan parked his truck within the dog's play area, prompting the other officers on scene to shout and gesture towards Roan, indicating that he should wait and let Ray get her dog. As Roan emerged from his vehicle, Jax began barking and approaching Roan. Roan responded by backing away from the dog and drawing his firearm, while Ray ran to the zip lead and began shouting Jax's name. In a short moment, Jax reached the end of the zip lead and could get no closer to Roan. Roan observed the dog could not reach him and further observed that Ray was now holding on to Jax's fully extended lead and continuing to call Jax's name. Roan therefore stopped backing up. Roan then took a step forward, positioning himself over Jax, and fired the weapon into the dog's head. The dog died from the wound. So let us just fully comprehend the totality of what's happening here. The officer decided to park near the dog, even though there was alternative parking. The officer observed the dog was on a lead that had a limited range. The officer observed the dog reach the end of its range. The officer had backed up previously, and after seeing the dog reach the end of its range, after having backed up and having seen the owner clawing onto the lead to get control of the dog, the officer then took a step forward as the dog was already at the extended end of its range and stood over the dog and shot the dog in the head. This is the factual predicate of what is happening here, guys. This is pretty messed up stuff that is happening at this point. This dog posed no actual or perceived threat. The officer was aware the dog was on a lead and could go no further. The officer was already out of range, and he stepped into the range of the dog in order to shoot it into the head. This is pretty messed up stuff. Is the officer liable? Let's continue. As to whether Ray sufficiently alleged that Roan's actions were unreasonable, the district court pointed to several facts in the complaint that led it to conclude the seizure was reasonable. Jax was a large dog weighing 150 pounds. Jax was alarmed by Roan's arrival. Jax was barking when approached by Roan, and Roan responded by moving backwards away from him, and the entire incident only took place in a few moments. The district court also pointed to several allegations it distinguished, such as the fact that Jax had reached the end of his zip lead and could not reach Roan. According to the district court, any reasonable officer would have felt threatened in the circumstances immediately preceding the shot and might not have been so sure that Jax no longer posed a threat. The important factor was instead Jax's proximity to Roan. The district court also held that Roan was entitled to qualified immunity. So the district court saw no problem with this. The district court said, well, any reasonable officer would feel threatened in these circumstances. Any reasonable officer would feel threatened by a dog who's tethered and could go no further and who is currently being controlled by its owner. And any reasonable officer would feel this way and decided that this officer had qualified immunity. So district court says This is totally not a factual problem. The officer was totally reasonable, and even if they're not, they're totally entitled to qualified immunity. So, what does the Court of Appeals have to say about this? Are they going to agree with the district court that this officer had qualified immunity, or are they going to disagree that this officer had qualified immunity? Please enter your bets now. We review a qualified immunity-based grant on a motion to dismiss de novo. To determine whether a complaint should survive a qualified immunity-based motion basis to dismiss, we exercise sound discretion in following the two-pronged inquiry set forth by the Supreme Court, analyzing whether a constitutional violation occurred and whether the right was clearly established. As an initial matter, it is well settled that a privately owned dog are effects under the Fourth Amendment, and that shooting and killing of a dog constitutes a seizure. Thus, we will affirm the district court's conclusion that shooting of the dog by Roan was constitutional only if we conclude it was reasonable under the circumstances alleged in the complaint. In weighing these competing interests, we focus on the circumstances confronting Roan at the moment he fired his weapon. Although we view the facts in the light most favorable to Ray, we disregard allegations of subjective intent in the complaint and consider only information known to Roan at the time of the shooting. So it's fairly typical in these kinds of things. We are not looking to what the officer subjectively thought or subjectively intended. We're looking to a reasonable officer, and it's an objective test. So we're not looking to this officer's subjective motives or even his subjective evil. We're simply asking the question whether or not a reasonable officer in these circumstances could reach the conclusion that there was a potential threat, regardless of the subjective motives or subjective thought or even subjective fear of the particular officer in question. Whether any officer in this situation could act this way reasonably. That's the operative question. Let's continue on. Applying these principles, Roan argues his actions were objectively reasonable because he was confronted with a 150-pound German Shepherd that was alarmed by his arrival, barking, and that in a short moment had advanced to within a step of him. Under the circumstances, Roan asserts that he reasonably felt threatened by Jax. As a result, Roan reasons the district court properly determined Ray's complaint failed to allege a Fourth Amendment violation. We disagree. So for all those out there who had lost hope on 1983 cases, that there would be a court who would say, no, this is not going to work. We found one, guys. We found a case where the court actually said, no, this is not going to fly. So all those of you who had bet immunity, it wasn't immunity. The court reversed the district court. Good times are being had now. Yay! The problem with Roan's argument, and thus with the district court's decision adopting it, is that it requires us to ignore certain factual allegations in Ray's complaint and to draw reasonable inferences against Ray on a motion to dismiss. According to the complaint, Roan stopped backing away from Jax when the dog reached the end of the zip lead and then took a step towards the dog before firing the weapon. These factual allegations yield the reasonable inference that Roan observed the dog could no longer reach him and thus could not have a reasonable belief the dog posed an imminent threat. Taking these factual allegations as true and drawing reasonable inferences in Ray's favor, Roan's seizure of Jax was unreasonable because Jax no longer posed any threat to Roan. And everyone's hope is slightly restored. A district court is saying, look, in this issue, we look to the evidence of the non-moving party because this is a motion for summary judgment. So we take the facts in the light most favorable to the non-moving party. To the non-moving party. In this case, the issue is, based on everything the homeowner says, is the officer liable? Because they're the non-moving party. And says, well, if we take everything they say as true, which we do for the purposes of this appeal, then the officer acted unreasonably. So we have some minor hope restored. Good times. Tellingly, in reaching the opposite conclusion, the district court relied on cases that were all decided on summary judgment involving one or more dogs that, like here, were barking or advancing towards the officer, but, unlike here, were unleashed or unrestrained and posed an immediate danger to the officer. Accordingly, we conclude the district court erred in holding the complaint failed to allege a violation of Fourth Amendment rights. We next turn to whether Roan is entitled to qualified immunity at this stage of litigation. On appeal, Ray argues that since at least 2003, we have placed Roan on a fair notice that the homeowner has a clearly established right to enjoy her dog, Jax, free from the officer Roan using unreasonably deadly force against Jax, particularly where the dog Jax was secured, controlled, and could no longer reach Roan. According to Ray, Roan's actions, killing a pet while that pet poses no immediate threat of harm to law enforcement, are unreasonable and contravene well-recognized precedents. In response, the officer contends neither our precedent nor our body of case law involving police dog shootings address the particularly unusual circumstances Roan has faced at Ray's home. According to the officer, there is no authority involving a 150-pound dog that has advanced towards an officer to within a step, alarmed and barking, a 25-foot zip lead contraption, or relevant facts to one similar here. So as we're all familiar with 1983 case law, the Supreme Court has cautioned that these issues may not be reviewed at a high level of generality. That is, you need specific cases that say that this is a right that's clearly established. So the officer is saying, well, it's not clearly established that I couldn't shoot a restrained dog who was 150 pounds and barking at me. There's no case that says that explicitly, so I must be off the hook, is the officer right? We disagree with the officer's contentions with respect to qualified immunity for the same reasons already set forth in our discussion about whether the complaint states a claim for a violation of the Fourth Amendment. Viewing all facts in the complaint and inferences arising therefrom in the homeowner's favor, it's clear the officer, Roan, shot Jax at a time when he could not have a reasonable belief the officer posed a threat to himself or others. Accepting these facts, we hold a reasonable police officer would have understood that killing Jax under such circumstances would constitute an unreasonable seizure of Ray's property under the Fourth Amendment. We acknowledge there's no direct on-point binding authority in the circuit that establishes the principle we have adopted today. There's no direct on-point authority, so surely there must be immunity, right? Because that's normally how these things go. The Fourth Circuit just said there's no direct on-point authority, so that must mean qualified immunity, right? Is our hope about to be dashed? Until now, we have never had occasion to hold it's unreasonable for a police officer to shoot a privately owned animal when it does not pose an immediate threat to the officers or others. Still, even without direct on-point binding authority, qualified immunity is inappropriate if the right was clearly established based on general constitutional principles or a consensus of persuasive authority. This is such a case. The Fourth Circuit just said, hey, even though there's not binding on-point authority, we don't care. We don't care. Even though there's no case that's clearly established in these particular circumstances, this is just completely outside the scope of anything reasonable. So, yeah, there's no binding authority, but still, you had notice that you didn't have the authority to shoot a dog who was posing no threat to you. You knew it, even though there's no case correctly saying it, because it was so well established, no one had bothered to say it because no one had needed to say it. Everyone was well aware of this. Why would we have said this? Everyone knows this already. This is obvious. So you don't get a pass for this one. You don't get immunity. Our hope is not dashed. It is restored once again. Yay! Based on the pre-existing consensus of persuasive case law, together with general principles we've already announced, we hold a reasonable officer in Roan's position would have known his alleged conduct was unlawful at the time of the shooting in this case. So that is the end of the case of Tina Ray versus Michael Roan. In this case, we learned that Officer Roan shot a dog, and he argued that he had qualified immunity. The district court said, yeah, no problem. We see no problem with this. We think a reasonable officer could have felt threatened in these circumstances, and we feel that this is something that's subject to qualified immunity. No problem. But on appeal, the Fourth Circuit said, even though there's no case law specifically on point, you can't shoot a dog who's posing no threat to yourself or others. One that you know to be restrained. One who you know can't go any further. One who has already reached the end of his lead and cannot harm you. And then you stepped into the dog in order to shoot it in the head. No, we don't need a case that says specifically that, because it was so obvious, who would bother to write it down? So no, you don't get qualified immunity. Go back to trial, Figure out if the facts are as this person says they are. And if they are, you violate the Fourth Amendment. So a qualified immunity case does not win even though there's no clearly established law. Because it was so obvious, we didn't need to say it. But now we're saying it, and we're also saying you're liable. So our hope has been restored. A 1983 case where an officer is not immune. This dog shooter will have to face justice, and that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.